Hey, welcome to today's video. I'm Richard Chapo. I'm an attorney in San Diego, California. I represent online businesses. So today we're doing a CCPA, warning on amendments and regulations. Well, what does that mean? Well, the CCPA is a California Consumer Privacy Act. It was enacted in 2018, and it is a strange law from a legislative perspective. So typically, as you may recall from the little cartoon we all watched as kids, when somebody wants to introduce a bill in an effort to have it made into a law, they introduce the bill to the legislature in question, and it goes to committee, and there are hearings, and various parties implicated by the bill or impacted by the bill have the right to testify. And then there's some political wrangling, and we have lobbying groups and all that, the 9 yards. And it's kind of like you're making sausage. Sometimes you don't like to actually see how the bill becomes a law, but it does. Now, whether you're in favor of the final result or not, the good news is during that process, there's plenty of time. And so the people drafting the actual language, they can address areas that are weak or would cause problems. So if, for instance, there's a provision in the law that conflicts with another law, well, they can modify that or remove it. Now, that process didn't happen here. The CCPA is unique because it was originally an initiative. And in California, we have an initiative system where you can bypass the legislature and the governor. And as long as you can get a significant number of signatures supporting your initiative, it goes on the ballot, for better or for worse. And that's what happened here. The original initiative received sufficient signatures, and it was put on the ballot for the election in 2018. Now that caused a problem because if you actually read the initiative, it was a disaster. Language was all over the place. There were major errors. There were major conflicts with federal and state law. It was just going to be a nightmare. And so through political wrangling of one sort or another, the California legislature decided that, hey, we'll work a deal. And they approached the backers of the initiative, or maybe the backers approached them. I don't know how it worked. But the end result was it was agreed that the initiative would be removed from the ballot if the California legislature went ahead and drafted and enacted the CCPA. And that all sounds nice, except there was a deadline. And so the CCPA was drafted and enacted in 7 days. There were no hearings, no committee hearings, no chance for businesses or individuals or privacy advocates to testify, very little lobbying, none of the usual stuff. And so we ended up with a law that has a lot of provisions that are making a lot of people very unhappy, including some of the California agencies. So, for instance, the original law included a clause that essentially required the California Attorney General's office to receive and respond to questions and proposed CCPA compliance efforts within 30 days. So if you were a business, you could submit your plan and questions to the AG, and it had 30 days to respond. Well, the California Attorney General's office doesn't have a department that does that. They don't do that. That's not a part of their normal function. Is very bizarre. And so, as you can imagine, the AG started raising a ruckus. So that was something that came up, and there were plenty of provisions that caused businesses all kinds of pain. Privacy advocates weren't happy with other provisions. And so the end result is that instead of dealing with all this before the bill was written into law or was voted into law, we're doing it now. And in September 2018, for instance, we had Senate Bill 1221 that was enacted into law, and it made major changes to the CCPA. It removed the AG 30-day review clause, for instance, as well as many other things. And we now have, I don't even know how many, 6, 7, maybe 8 other amendments before the legislature. And it looks like some of them will, in fact, be passed and enacted into law, signed into law by the governor. Which ones? Your guess is as good as mine. But the bigger point here is to recognize that you need to keep an eye on these amendments. You need to make sure that the version of the law you are looking at is the correct version, the updated version, if you will. If you are looking at the text from the law as it was enacted in June 2018, you got the wrong version. On top of this, the Attorney General is supposed to enforce and issue regulations on the CCPA. and it is trying to do so now. It's trying to put the regulations together. It's been holding hearings, but to give you an idea of just how odd this process is, here were four of the categories off of a recent agenda meeting held by the AG. A, categories of personal information. So we're still arguing over what's personal information, what's not, based on some of the language used in the text. The definition of unique identifiers. What is a unique identifier? CCPA, PA exemptions. There's issues with the exemptions. How broad are the exemptions? There's even one of the topics was even the opt-out, opt-in button requirements. So there are provisions in the CCPA that require you as a business to allow consumers to opt out. In some situations, if you're dealing with minors 16 and under, you have to have an opt-in button. And how is all that process supposed to work out? And so it's a good bit of confusion. So there we are. Now the AG regulations, we're hoping to see the first draft in the fall of 2019. And that will hopefully help maybe clear up some of the stuff. Of course, the AG regulations can also change, and probably will to some extent. But nonetheless, we'll have some more definitive guides for how this process should work. Now, the strange thing about this, of course, is the first part of the CCPA. It goes into effect in January 1st, 2020. And that applies to breaches. So if there's a data breach of some sort, i.e. you got hacked, you'll have to comply with that part of the law. Now, whether there's a private right, when that can go, when you can be sued, all those kinds of things is still up in the air. But the rest of the provisions, the record-keeping requirements and things of that sort, don't go into effect until the summer of 2020 or sometime around that period. It's basically whenever the AG finishes the regulations. So while it's interesting and fascinating from a legal perspective, it's a bit difficult from a planning perspective. But nonetheless, it's important. Just the best you can do at this point is make sure that you understand that this law is probably going to be amended quite a few times and that you're up to date, and make sure you have the latest version of the CCPA so you don't take a position based on antiquated text that gets you into trouble. So that's it for today's video. If you have any questions or comments, post them below and I'll try to answer them. Thank you for watching. Have yourself a good one.